So we'll just commence. You do have the material. We gave you the course material, and you have the slide presentation, and we'll just go from there. Just to give myself a little bit more background, my primary practice areas, corporate and commercial business litigation transactions, and other practice areas include trust and estates, estate planning, and business succession planning. I received a Juris Doctorate from Northeastern University School of Law, and then afterwards I received a Master of Law in Corporate Taxation from the New York University School of Law. I've been admitted to the New York State Bar and admitted to practice in the U.S. District Courts for the Southern and Eastern Districts of New York, U.S. Court of Appeals for Second Circuit, and U.S. Court of Federal Claims. I've also been admitted pro hac vice in several state and federal courts, including one state and federal court matter out of the state of New York currently. So we're going to begin with cross-examination of experts at trial, and we have a number of items to discuss before we get actually into the cross-examination itself. One of them is I wanted to address the Frye standard versus Daubert. We're not going to get too much into that, but I figured that it was well worth going over because sometimes an expert may be providing testimony that you question whether it involves a new or novel theory, or it obviously does. And you want to make a motion to seek a Frye hearing on that basis. So you've probably heard of Daubert and Frye. In Daubert versus Pharmaceuticals, the Supreme Court held that the Federal Rules of Evidence, Rule 702, superseded Frye as the standard of admissibility of scientific evidence. However, some state courts, including New York state courts, still use Frye. So Rule 702 of the FRE is the standard as a result of the holding in Daubert in federal courts. I cited to a case which is in your course material, which is Solid 21 Inc. versus Richmond, North America. That is Southern District of New York case, federal court. It was decided September 18th, 2023, and involves expert cross-examination of experts and motions in limine, and it's an interesting case to read. I'm not going to go into the whole Frye case that is cited in your course material, including the standard that was applied in Frye. But the Frye standard applies, like I said, in state courts in New York and a few other jurisdictions. It's used to determine the admissibility of an expert's scientific testimony for new and novel types of evidence. And it stands for the proposition that a proponent of novel or new science must establish general acceptance among scientists within the relevant discipline to justify its mission. So we'll go on to the next slide, which is, I think, slide 4. And the title of that is, we continue with Frye, in addressing Frye. Under Frye, the threshold of confidence is the general acceptance, while Daubert applies reliability standards that are set forth in Rule 702. And since the courts act as gatekeepers, the court must determine whether a Frye hearing is warranted when it's brought up that somebody is objecting on the basis that the expert wants to testify and opine on a novel or new theory, not accepted, they're claiming, by the scientific community. And in making the determination of whether to hold a Frye hearing, there's a difference between whether the objection relates to a novel or new theory, that is, the objection claims not generally accepted, and based upon the expert's own unsupported beliefs, versus, competing expert theories on issues, such as causation, which involve making credibility determinations, entailing weighing of the evidence, and that falls clearly within the domain of the jury. And therefore, if the court determines that that's the case, really, then a Frye hearing will not be held. Motions in limine. they're the first course of action against challenging the qualifications of an expert or challenging expert testimony on a particular subject matter by seeking to preclude certain testimony and opinions. Motions in limine are very helpful to get these issues before the judge presiding at trial. Often, motions in limine will probably be held in abeyance pending trial so that the court will have time to hear the arguments, have time to hear how they're going to be presented in the proper context. And oftentimes, motions in limine will just simply be, held pending a ruling at trial. And that's when they should be brought up again. But they can also be brought up and asserted through objections. So we're going to talk about different motions in limine. One of them, the point heading, is bolstering. That's on slide 5, titled Motions in Limine. And I cited to People versus Spicola, which was in the course material. And this involved a criminal matter. I'm not involved in criminal matters, but I thought it was pretty interesting. It involved the conviction of a defendant for sexual abuse of a minor. And the defendant argued on appeal that certain hypothetical questions testified to by the expert closely mirrored minor's circumstances, and it resulted in properly bolstering or vouching for the minor's credibility to prove the charged crimes actually occurred. And this argument, like the court said, was not preserved because the questions were not objected to at the trial, for one. And the court determined it was offered for purposes of rehabilitation because the expert did not express an opinion on the minor's credibility during the trial, and in fact disavowed that he would express such an opinion. Hearsay is another one. Acting as a conduit, for instance, to admit otherwise inadmissible evidence through an expert's testimony. This is seen a lot, and whether it is successful depends upon a lot of factors. This is important, though, to try to preclude when the source of the hearsay is not available to cross-examine and impeach, or those sources are, may be hearsay in and of themselves. I cited to Boyer versus Zono in the course material, and that involved defendants' motions which sought to preclude plaintiffs from offering cumulative expert testimony or hearsay testimony regarding conversations with non-parties and unidentified people. It was denied as premature on the basis those issues would be ruled upon at trial. Prejudice is especially notable. This could involve a suggestion to the jurors by the expert about how much the jurors would wish to receive for damages in a similar situation, but putting themselves in the place of the plaintiff. Or it could amount to instances where the expert seeks to testify about supposed similar circumstances to suggest that liability in those cases were found and should always be found, as in this case, without the proper context. That could be prejudicial depending upon the presentation and context. And a trial court, and this is in the court's material, has determined that the trial court may exclude even relevant evidence in its discretion if its probative value is substantially outweighed by the danger that it will unfairly prejudice the other side or mislead the jury. And I cite Tyre versus Merit Construction. And I found this case interesting. It's 2015 state case, in which plaintiff's motion to preclude evidence she smoked marijuana and that she was impaired at the time of the accident was granted because although relevant to causation of the accident, it could not be said, given the record, that the probative value of such evidence was not substantially outweighed by the prejudicial effect. And the court relied on the record of the facts and the evidence and the deposition testimony of plaintiff and others, including witnesses, including the police at the time of the accident, in which it was shown that there was no evidence the plaintiff smoked marijuana or was impaired. And therefore, of course, the probative value it was substantially outweighed by the danger that it would unfairly prejudice the other side and mislead the jury, although relevant on causation. I cited to a couple of other cases as well. One of them was Hassett versus Long Island. And the court reserved decision on a pretrial motion in limine. And after the court granted the defendant's motion in limine to exclude plaintiff's expert testimony after trial, it also granted a JNOV in defendant's favor because plaintiff could not make out a prima facie case without the expert's testimony. And the court reasoned the decision did not prejudice plaintiff because plaintiff knew that the court, because a motion in limine had been made pre-trial, might potentially strike the testimony. And what they could have done is supplemented the expert testimony with other proof, and they didn't. And that's why it's very important to raise these motions in limine pre-trial. This is a prime example, and also to raise them after trial, during trial, and through objections. Another one was the Solid 21 case that I referred to a few minutes ago. It granted in part motion in limine following precedent excluding expert testimony that expresses a legal conclusion. And in that case, the expert wanted to offer legal conclusions about what the advertisements are potentially infringing, to suggest that, you know, if these categories, if it falls into these categories, they are infringing as a matter of law, and to present categories of damages calculations based on an application of, I guess, the prior court rulings that were held in that case. The other bullet point is the failure to comply with expert discovery. And of course, under the commercial division rules, you know, if you don't comply with expert disclosure within the time periods and you don't have good cause, they're going to be precluded. Schwartzberg versus Kingsbridge was another case that I cited in the course material. It involved a breach of contract action. Supreme Court granted plaintiffs 2 pretrial motions to preclude the defendants from presenting any evidence or calling an expert witness to challenge the final accounting, which was affirmed on appeal. And the court held that, you know, under the CPLR, it does not establish a specific time frame for expert witness disclosure. Commercial divisions do, but CPLR does not. But a trial court still has the discretion to preclude expert testimony for the failure to reasonably comply with the statute. And by precluding defendant's expert was based on defendant's failure to offer any explanation for an inordinate delay in disclosing the identity of the expert, credentials, and the specific subject matter, something that is very, very pertinent to expert disclosure, to place the other side on notice and to allow them to prepare for trial. I cited other cases. We don't have time for those, so you can read them for yourself in the course material. Qualifications is another one. I won't go into that because, you know, I want to make sure that we cover all bases. But whether an expert's qualifications or the foundation's the opinions that will be offered at trial meet the threshold of competence for expert testimony or require a Frye hearing. In finding that the nature of the defendant's objections to the proposed testimony of plaintiff's experts did not require a pretrial hearing, addressed to admissibility under either general acceptance or reliability and standards of Daubert, in which I cited to Delgado versus Markowitz Sporting Goods, a state court case. The court stated that matters going to trial foundation or weight of evidence are not properly addressed in a pretrial proceeding addressed to such issues in denying the motion. One thing is observed is that titles of the expert don't matter. If the expert has experience in the field or a similar field, it's going to be likely enough. It is not enough to argue that the expert or the other side's expert does not meet the qualifications to testify about the causation. For instance, I cited to, for example, a building collapse or whether proper repairs were made prior to the building collapse. It involved a case that unfortunately wasn't included in the course material. I thought I cited to it. I can find it if anybody is interested. But I think it involved, in that instance, somebody who wanted to testify, and the other party argued they're not an engineer, they don't have the expertise or qualifications to opine on this issue at trial. But the court found if they're an architect or a safety inspector and they have experience in the field, that's enough to meet those qualifications. A layperson can be an expert as long as they are offering what is deemed to be expert testimony. Every situation is different as to whether the qualification should be the subject of the challenge. Moving on, we get to the objections. And objections is another way of raising and reminding the court of any issues related to the experts, the other side's experts' trial testimony. And we get to those before we conduct the cross-examination, because if they are stricken and precluded from testifying on certain matters, then there's no reason to cross-examine them on those particular matters. Before cross-examination, during the other side's direct examination of their expert witness, there's an opportunity to object and raise an objection to preclude the testimony in order to avoid the very circumstances I just discussed. If it is sustained, the objection, then you won't have to cross-examine on that particular subject matter. If the testimony of an expert is not stricken or precluded on a motion to eliminate, you're reminding the judge again of the presiding judge over the case of the issues. You're also, though, educating the jury that the other side is doing something that you consider improper. And I think that objections are, they're a matter of taste. I think that when somebody is being argumentative and it's your expert, obviously, you want to disrupt the flow of the testimony. But when it comes to the direct of the other side, I think that less is more. I think that circumstances in which you want to object is that if the testimony is prejudicial or violates a ruling by the court, including if there is a close question about whether it is prejudicial or may violate a prior ruling on a motion to eliminate, for instance, or the issue to preclude testimony came up in a motion to eliminate, you want to preserve that, even if it was undecided by the judge. You need to preserve it, and I cited to Almonte versus Consolidated Edison, and then I cited to the People versus Spicola case. Almonte involved a commercial case, I believe, and People involved that criminal case that I was referring to. Also, another reason for raising an objection at trial is to the extent that the questioning extends to subject matter or conclusions beyond those that were ever disclosed in an expert witness's disclosure and not raised before. That could be proved prejudicial because you weren't placed on notice, given the opportunity to prepare, and the failure to raise objections will probably mean that, even if there's an appeal, it will be determined you were on notice, you failed to object, and you suffered no prejudice. So it's important to raise those objections. On the other hand, though, I think that less is more with objections when it comes time to the direct examination by the other side of their expert or factual witness. It's easy to fall into the trap of fighting, objecting continually. I think especially at the start of the trial. I think after a while you learn what the judge responds to, and it's better able to, I guess, resist the temptation to overdo it. You want your objections, first of all, to stand out, to make them when you need to make them. And overly objecting, of course, always can give the impression before a jury you're trying to obstruct the development of testimony. And of course, that implies it would be unfavorable to your side. And even if you're right and the objections are sustained, if it's done so repeatedly, it really is a Pyrrhic victory, because it can be perceived that you're just trying to disrupt the flow to disrupt the flow. So if it's not critical and not one of those points that I mentioned, it's better off addressed at cross-examination. But of course, there are always exceptions, and I leave that to your judgment. Objections should educate the jury that something the other side is doing is improper, and what they are designing to achieve. Those types of objections are really helpful because they do educate a jury that otherwise doesn't practice law and may not know why the objection is being asserted. But again, we fall back on, if you're too busy objecting, not only does it leave a bad taste in the mouth with the jurors, perhaps, but you're losing time listening to the expert and observing and strategizing. If you do need to object and cannot state your objection clearly, and you need time to formulate it, there are background reasons, maybe perhaps connected to a motion in limine and the arguments that were made that need to be brought to the judge. You seek a sidebar, and permission to state your reasons. The worst that can happen is the judge says, no, move on. But those, I'm finished with the objections, and I think that we're going to move on with the preparing questions and strategy for cross-examination of the other side's expert. So there's many different ways to prepare. You review the expert's report and the disclosures. Now, in part of the course material, I went into the expert disclosures. I went over the commercial rules. I cite those and what those rules are and the time periods for them. I also cite to CPLR 3101D. There's always instances that are in CPLR 3101D that relate to, kind of malpractice actions that are different related to expert disclosures and those types of actions. I don't do those, but they are cited, including some case law related to expert disclosures, and you can read that at your leisure, I guess, if you're bored at night, or you're interested in reviewing it. So I start off with a number of things. I look at the CV, but we'll start off with the expert, reviewing the expert report and disclosures. I usually review them very, very carefully in order to highlight the opinions that are most critical to their side as well as most vulnerable to effective cross-examination. As one course. And also I do the same with documents. What are they relying on? And what are they emphasizing in the report? What do I need to undermine? And what is vulnerable? If there's a deposition of an expert, and there are, in most cases, including under the commercial rules, unless it's the type of case where you either side won't have an expert, then prior to trial, I really go back to that deposition. I really go over it very carefully to observe, including whether an expert maintained their position and failed to make any concessions during the deposition when faced with facts that cannot be denied exist. They're on the record. Nobody's disputed them, and that should be focused on at trial, because denying the undeniable leads to questions regarding credibility and whether the weight of the testimony should be limited, bias and so forth. That can be helpful. I also want to determine how they handled being evasive, because I think that anybody who's conducted expert depositions, and I'm not trying to disparage experts by any means, but knows that some of them, they handle trials a lot, and they've learned how to be very evasive and deploy certain tactics when, they want to divert testimony because it's getting uncomfortable. It's leading to something that is unfavorable to their other side, and they're a hired hand. They're working for the other side. I also try to limit the number of documents used to focus on the documents that will impeach the expert and those that are really most critical to the underlying issues of the case. I conduct a lot of research. It can sometimes be like a needle in the haystack, and we'll get into this because this kind of flows into the curriculum vitae. So we're moving on to research. So if depositions of expert witnesses or cross-examination trial are available in another case, a different case, it's well worth trying to search for those and to review them to see how the witness reacts and the tactics the witness deployed during the cross-examination, during trial, and during the direct examination if it's on some sort of relevant issue. Sometimes you can observe that the expert has a tendency to use inflammatory language, alarming language that is designed to incur an emotional reaction from the jury, has a tendency to overreach in their opinions, or has even taken a similar but taken a contrary position for the opposite party and used similar language that was either in their report or during their deposition in another matter that is, similar. That can be used against the expert at trial, and if it can't be used, at least you have the information and knowledge, and they say knowledge is power. That may sound corny, but it is. It makes you feel well prepared and at least confident that you can tackle the expert testimony and the objections and the cross-examination especially. I find that the expert's curriculum vitae is your friend, and we're moving on to that subject because
Carol,
I found...
Can we actually take a moment to break? We're going to do the first course code and then we'll move on to your next slide.
That's a great time to break. Sorry, I was just looking at the computer.
No, you're fine. So the first course code is going to be 476482. Again, the first course code is going to be 476482. And I'll leave this up on the screen for everybody to write it down from. One moment. All right, we'll move on to the next slide now, Carol.
Okay, thank you. Sorry about that, Taylor. So I believe that the curriculum vitae is always your friend. I've found a lot of interesting details that can be used to raise issues about the credibility and the bias of an expert on cross-examination just through going through the curriculum vitae in detail and, conducting research. So you're looking, in the curriculum vitae, you're looking for a couple things that I look for. Possible black holes where dates of experience are missing, inconsistencies in dates, if publications are disclosed in the CV, determining whether those publications on those topics were actually made, and if so, if they're an authority that the expert is relying on, whether they actually state what the expert claims that they state, or whether they contradict the expert's position in the particular matter, or they related to, for instance, different factual scenarios that are just not present or not unsimilar circumstances. Also, the curriculum vitae, if you look at the cases listed, can you determine whether that expert has testified in numerous cases and whether it's unbalanced, more to plaintiff, less to defendant. That can sometimes be helpful, at least And that can also be used for looking at cases, and I found this before, in which the expert appeared to testify and the CV submitted in those cases was available, but it was different. It had missing information, changed information regarding qualifications that is inconsistent with the present CV, publications that are not disclosed on the present CV, and so forth. Or articles that were never published that claimed were published. So I think that it's the whole gist of this is really to look at whether the expert's credentials are overinflated or misrepresented in the action, and to use the other CV to show that or to raise that at least as a question at trial. A CV can also show or raise questions as to whether the expert really has a type of expertise that is relevant to the facts of the case. They may be qualified to testify as an expert, but they may not possess such expertise to really give them the weight that they should. And also can be used too to, question saying, well, you've been in a number of other cases, but you've never opined during trial or during a deposition or in any other matter regarding the specific dispute in which you're now testifying. The next, and moving on to that, another thing that I've done before is research whether an expert has ever been sued by a party or a client. For instance, if you have a valuation expert or a survey of property that caused damages, or for not, if you're in a commercial case and they haven't followed accounting practices, tax advice, or there's even malfeasance outside the profession that can raise issues with the expert's credibility and, limit their weight or the weight their opinion should be given. Researching determine whether a court ever precluded the experts, another one. And another thing that I found too, and this depends upon the type of experts. If you get an expert that's very scientific and has a very specific field, a niche area, you're never going to be an expert, but you don't have to be. There's many sources that you have available to you in order to become educated. One of them is using the report and using your own expert, which I find is very, very helpful because they're probably going to be in the same or similar field or overlapping field. They know the terminology, particular terms of art, and they can help you in kind of pinpointing anything that is critical to ask the expert or to point out and raise through leading questions to show that, his opinions, the weight should be limited for any reason. It allows you to focus really on what's important. So they're a great source to assist you also in formulating questions, because when they involve particular terms of art, oftentimes an expert will deviate and say, oh, I don't understand the question, or, they claim, they kind of fall back on the term of art and they say that something's flawed or, whatever it is, the question. And if you know how to formulate those questions by interjecting and becoming educated about the particular field, it'll be much harder for the expert to do that without the jury noticing that they're dodging and that they are not answering the questions. You also, the goal is to show why the opposing counsel's experts' findings and methodology are flawed, or that they raise the specter of doubt. The expert's assistant, your expert's assistant, not only goes to the trial testimony, but it really starts with expert depositions as well. And that the same factors that I expressed in terms of using your expert as a source apply. It's also valuable if your expert has the time to sit in on the deposition of the other expert, because observations can be made, and even through, breaks and so forth, it can be discussed about follow-up questions or about something that the expert testified to that should be, revisited. So I think that the gist is that when it comes to experts, period, but especially with experts in specific areas, be inquisitive, conduct research, use your sources, and ask, your own expert about their field and become, as knowledgeable as you can. You can also use your own client too. Depending upon whether your client's business is in a particular industry or whether it be a franchise or a manufacturing or retail, wholesale, whatever it is. Also, if the particular matter involves accountants or somebody who's going to testify as a general manager, financial statements, and so forth, that can be very helpful, not only with cross-examinations of experts, but obviously with other factual witnesses as well. So we go to questioning the expert, the tips and strategies. Some of the things that I do initially is if the trial is before a jury, when using an exhibit, a CV or a report, I always point out what the topic is and why I'm asking it, whether it be a point heading or a statement that was contained in the CV or the report. So the jury can be informed that we are transitioning now from one topic or one subject matter leading into another. Oftentimes, juries can get very lost because they are not lawyers and they are also not involved in particular industries. So it really depends. But it's, I think, a valuable practice to try to keep that in mind, and that can easily be lost. You try to get the expert up there, and you want to cross-examine, and you just want to get your questions out. But slowing down and saying, okay, now I'm taking you to blank, and you made a statement of this, or you relied on this document, and knows that we're transitioning. I take advantage of asking leading questions. Now, we all know that, we should ask leading questions. Not all questions are going to be the type of questions that you can assert in a leading question. But leading questions are important, of course, to keep in mind and to use to direct the scope of the examination, place the expert on, the stand literally, and also by framing the question as, isn't it true? Just making it solely through, it doesn't permit long, lengthy narrative responses that are sometimes circular and the point gets lost. Leading does help the jury too. What are you asking? Why are you asking it? And it, assists in the examiner just maintaining the control over when information gets released and what information is conveyed. That helps the jury as well because they're taking it step by step, and you don't want to get lost in the forest. So try to avoid questioning which permits a narrative response as much as possible. When there's a narrative response, oftentimes if it involves an uncomfortable question, the expert will, that gives an expert the opportunity to give, a full court press, give circular reasoning that doesn't really answer the question, but yet they're giving a somewhat verbose answer that hides or conceals, that they are in fact avoiding the answer to the question directly. And it often undercuts the very point of why you asked the question in the first instance. And it often leads the questioner astray. I know that it's happened to me. If you've conducted expert depositions, it's probably happened to you. And then you have to go back, and you lose time if you have to go back deconstructing. I attack the expert's qualifications on the curriculum vitae, such as puffery, if they exist. And of course, these expert tips, they're not going to apply to every expert or every situation. There's just different tips you can use if the matter presents itself, if the situation presents itself. But oftentimes questioning on credentials, what was put on the CV, what doesn't comport with either other CVs or the credentials themselves. Whether the expert has the type of expertise that is relevant to the dispute. and whether the expert witness, whether your expert witness knows that witness as well is also helpful. And the reason for that is if they are in a particular field, they might know each other or they might know people who know them. And that's also good to gather information that you could be used for questioning or at least preparing for trial. Questions to extract the extent or limitations of the expert's practical experience in their field of expertise as compared to the time they spend maybe on the stand, to suggest that, you know, really they're a hired hand. They don't really have the type of field experience if the percentages are unbalanced enough to make it worthwhile pointing out. Another area too is, you know, the type of cases they've been involved in. Say, for instance, you have a damages expert and they've only been involved, they've listed a lot of cases. They had nothing to do with judgments that were issued in favor for a party they were testifying to, but were in fact related to mediation or settlement discussions. To point that out, to show that the cases do not relate to the subject matter or the awards, and show maybe that the expert's evaluation is relying on sources that are unreliable in order to lead to you know, evaluation that is just not it's nothing more than conclusory, and it is not supported by reliable sources. How much an expert is paid to highlight payment of excessive fees. I mean, again, that depends, but if they are paid highly excessive fees, it shows that, you know, they're taking the position of any party who can afford them to impress upon the jury. They're nothing more than a hired gun, or what we call a so-called utility witness. If their CV presents that type of situation, and, you know, they've been paid highly excessive fees and been in a number of trials, that might be worth pursuing. So the other one is also to ask questions to try to corner the expert, show the experts acting as a conduit and advocate for the other side. Show the expert denies the existence of factors. This is especially important. I highlight it again. They are denying the existence of factors that are unfavorable to their side's position in arriving at their expert opinion, or they are denying facts that are unfavorable, although they cannot be denied because they exist on the record and they have been admitted into evidence. Also, it's worth showing, too, because I've seen this, ask questions about statements, facts derived from the record, and exhibits or documents relied on by their side. Because often is the case, the expert may not have relied on them. They may not be mentioned in the report, although they have been relied excessively by the other side. Or the expert, upon questioning, denies that they are relevant, or is unaware of their existence. This I've seen before because this has happened. Or the documents disagree, or the expert disagrees with, I guess, the content of the documents and how it supports, you know, favorably their side that they're testifying to. This can show that the expert's not in line with their party with whom they're testifying to. They're not in line with their own position. And it can show that maybe the party withheld certain documents or information, never presented them to them, because they knew that if they did present it to the expert, it would not be as favorable. The opinion would be negative, perhaps, or different. And if that is the case, follow-up questions to explore why. Try to corner the expert about, you know, why they think that, you know, a document was not presented to them, or why, you know, why was a document been relied upon by their side, and they are not relying on it for their opinion. Also, another one, I've seen this, I've done it, question the expert about what their role is that led to the opinion. This can often lead to the fact that the expert did not conduct the work directly, maybe not even the report, because it was basically prepared by subordinates. Now, the expert probably oversaw those subordinates, but it can be used to demonstrate the expert does not have knowledge related to any document or any preparation of a diagram, a spreadsheet that was prepared because it was prepared by subordinates who are not present to testify, to show, hopefully, that the expert is really unfamiliar with their preparation, lacks knowledge about whether it's correct, whether the subordinates relied on the proper information in preparing it that was relevant in connection with it, or that the subordinates lack information about maybe inspection or testing that is part of the preparation of a document, and how to show that it's possibly faulty. There's faulty reasoning in there. And this is, of course, to impress upon the jury that the expert's general lack of knowledge connects to his own opinion because he's undertaken a limited role, and that the documents that were prepared and are being relied upon and in connection with the opinion are in fact faulty or should be, credibility and weight should be raised. So I guess the point is that the questions that reveal the expert lacks knowledge or fail to consider facts or documents that they consider unfavorable raises other issues that are really helpful on cross-examination. Expert reports and disclosures and expert tactics, again, focus on the most vulnerable aspects for cross-examination. And whether an expert witness will testify concerning a particular theory that has been relied upon by another expert witness in a similar case is information that falls within the rule requiring their side to disclose the subject matter and the substance of the facts and opinions on which their expert is expected to testify. That hasn't happened. That's going to be an issue. The expert opinion is not based upon their own perception. If the opinion is solely on the basis of perception, undermining the opinion is nothing more than a guesstimate, not based upon reasonable methodology. These are some of the tactics that you use to bring this out. Try undercutting the subject opinions based upon the lack of any testing or inspection, or based on, again, the unreliable sources. And I've used this before, the lack of any testing or inspection, to say, how could you say this in your report when you haven't conducted the testing or inspection? And I cited in the course material to the Delgado case, when the expert's testimony was offered at trial, technical or scientific basis for testifying experts' conclusions ordinarily need not be addressed as part of the proponent's direct case, because it falls on the opponent of the testimony to bring out these weaknesses in the expert's qualifications and foundational support on cross-examination. That might limit its weight, and that's good to keep in mind. Point out the expert did not look at important information, documents, or data when rendering their opinion. Focus on the elements of a claim, defense, or counterclaim, and try to obtain admissions from the expert on one or more of those elements that are at issue and critical and favorable to the party you represent. And your expert's position is also well worth it. If the opportunity presents itself, I would certainly focus on that. So to do that, you have to have a clear idea about the significance of certain factors that are relevant to the dispute, including the documents for conducting such questioning. But if by the time of trial, you should be, of course, have a clear idea about the significance of certain factors and that are relevant to the dispute and really what is critical to bring out. You also want to show and use documents to raise the specter that the other side did not want the expert to see them because it would have changed their position or opinion. And we go back to what I said a few moments ago. It would have undermined their opinion, or if the expert was aware of them, unaware of them, that the expert chose to ignore them because they are unfavorable or negative. In certain areas of expertise, like we talked about before, the expert's going to default to using terms of art that are very specific to their field to avoid or evade answering questions. Sometimes they claim they can't answer a particular question because the question is not being asked correctly, it's not understood, does not contain all critical criteria or facts that they need to answer the question. Bring out during the cross-examination that their answer that doesn't contain all criteria or facts as, you know, a justification for not answering the questions. What they mean by that is it doesn't contain the critical criteria or facts that they deem favorable to their side. So that's one of the strategies to assist in overcoming the dilemma and being poo-pooed away by an expert. You can also, you know, cross-examine through leading questions to show that the expert is just suddenly, overly, and extensively falling back on scientific jargon, terms of art, as a basis to conceal flawed methodology or analysis, or to avoid answering the question because there is flawed methodology or analysis they don't want to come through. You can follow up by asking, you know, if the criteria or facts that they claim they need to answer the questions were adjusted or modified, why is it that they still can't answer the question? And if they claim they can't, then fall back on, well, you're an expert. You know this more than anybody else in this room because it's true, they do. And if the criteria or facts are adjusted or modified, the follow-up question is whether they would reach the same opinion or conclusion. And to go back and revert upon, you know, if they claim that they can't answer the question, to point out that they're not answering the question, they could because they're an expertise in this field. And the criteria and the facts don't have to be the same because they've testified in many cases. So if faced with an expert who claims they don't understand the question, hypothetical, or needs more information to answer it, you know, again, you fall back on, hey, humor me, and rely on your own knowledge and expertise to answer the question. So trying to frame the questions designed, and we fall back on leading, to demonstrate the expert is refusing to answer the question. And to maintain the emphasis, they are consciously failed to consider or omitted certain critical information, documents, and facts from admissible sources because they're unfavorable, and that they don't want to answer the question because it will lead to an unfavorable result that is undermining to their opinion. Even if the expert continues to dodge, and some of them are very good at it, they just won't answer the question. The best that you can get achieved is that the expert absolutely just says, I didn't think about it, I can't answer the question. That shows they don't want to answer the question, or they're, at least if they don't answer in that fashion, they are openly acting evasive. They're making excuses that an expert in their type of expertise should not make or have justification to make, and that they're making these excuses because they don't want to really show that they are refusing to answer the question. And that is, you know, leads to, you know, possibly impressing upon that they won't because it is unfavorable. It undermines their opinion. and how much weight their testimony should be given. Even if your expert is not able to be inside the courtroom during the other side's expert testimony, you can speak with your expert on break if there is a break, and confer with your expert about, possibly crafting further questions to draw out further information during the cross-examination. So, and even if you get denial after denial, refusal to answer certain questions on critical facts, what you can do is at some point you're going to have to, give up the ghost to move on, because you're only going to have certain lengths of time during cross-examination at trial. You're not going to have all day, likely, or if you do, you still need to get to other matters. You can use your own expert. When it comes time for your own expert to take the stand, you can ask your expert on direct the same questions you ask the other side's expert. And your expert, when they answer, ask whether your expert would need to know any other information, criteria, or facts in order to answer the question, as claimed by the other expert. And ask whether your expert would be unable to answer the question without the criteria, information, or facts the other side's expert claimed they needed to answer the question. And your expert, they answer, no, they wouldn't be unable to answer the question, to raise a specter, again, that the expert on the other side just didn't want to answer those questions. Hypotheticals on cross-examination. Using hypotheticals is helpful to place the expert's opinion in context and to guide the presentation on cross-examination. And we go to CPLR 4515 in state court. Provides in part that unless the court orders otherwise, questions calling for the opinion of an expert witness need not be hypothetical in form. The CPLR, is drafted this way because of the history behind it, but the CPLR does not prohibit the use of hypotheticals. At one time, it was necessary to ask a hypothetical if an expert's opinion was based in whole or in part on facts not within their personal knowledge. It's no longer the case, but it doesn't mean hypotheticals can't be used. They can. If the other side on direct opened up hypotheticals and used them, they can certainly be used. They've opened them up, and you can ask on cross-examination the same hypothetical. They can be used as long as they're relevant and they relate to an expert's report and their findings. And I cited to a case, U.S. Dredging Corp. Versus Lexington Insurance. That's in your course material. Stands for the proposition: a hypothetical used to elicit opinion testimony must be based on facts admitted in evidence or fairly inferable from the evidence. And in a case involving the denial of insurance coverage under a policy related to a peer, the trial court properly sustained objections to the line of questioning which plaintiff sought to elicit from its expert that wind was the cause of the incident due to plaintiff's failure to establish a proper foundation as to the basis for that opinion, because the evidence presented by the plaintiff demonstrated the pier had been structurally compromised for years and years through wear and tear, and it exhibited extreme levels of deterioration before its collapse. And therefore, they couldn't elicit this from their expert, and this wind theory was not allowed to be testified at trial. I cited to Bannister as well. Bannister versus Marquis, the trial court should have prohibited defendant from questioning plaintiff's expert witness using a hypothetical, as a hypothetical is not based on facts supported by the evidence, nor from facts fairly inferable from the evidence. And in Federal versus Port of New York Authority, that was a negligence breach of warranty case. It was error to disallow hypothetical, which plaintiff sought to ask the expert on rebuttal, because plaintiff was not required to include in that question every bit of evidence in the case, favorable and unfavorable, and missing or contrary matters. Those could be brought out at cross-examination. In Ryan versus Lynn Company Lumber Corp., in action involving claims of breach of implied warranty of merchantability and product liability. Although the court sustained plaintiff's objection to defendant's expert's reference to a test report, not in evidence, and instructed the jury to ignore the references, an expert may express an opinion based upon assumed facts in the form of a hypothetical question, so long as the facts assumed are fairly inferable from the facts adduced on the record and based on facts personally known to the expert, and finding the testimony of defendant's expert met those standards and should have been allowed to testify. I also cited to Sumowitz versus Gimbel Brothers. The defendant's expert was allowed to use a hypothetical which plaintiff claimed was only brought out by cross-examination of the expert. But again, it goes back to opening the door, because the record revealed that on direct examination, plaintiff used that hypothetical to elicit testimony from their own expert. The jury was permitted to weigh the evidence, evaluating the claim and the defense by allowing that hypothetical on cross. One thing to keep in mind, it is improper to ask an expert to express an opinion based on all evidence in the case or based on evidence outside the record, unless it's of the kind accepted in the profession as reliable, informing an opinion, or if the information comes from another witness that's not subject to being cross-examined, or other evidence is presented to establish its reliability that has been admitted. If the information comes from an out-of-court source, such as a document, although the expert can testify they relied on it, the content can't be read or testified to by the expert unless admitted into evidence by the testimony of a person subject to cross-examination. Otherwise, the document's hearsay unless there is an exception to it. And this also applies to publications. On cross-examination, a publication the expert claimed that he relied on, if established as authoritative, can be used for impeachment and read during cross-examination to show the publication doesn't support the expert's opinion, it's contrary or it's inconsistent, or it relied on evidence that is substantially differs from that in dispute, or that the evidence differs from the evidence the expert relied on or concerns a different subject matter. So I also cited to Bryant versus Bryant and Benson Berman in the course material. The trial court properly allowed the use of the medical text to impeach the credibility of an expert witness who had acknowledged the text as authoritative. So it's always important, going back to, again, the CV and research, to use these possibilities during the examination of the expert.
I'm going to show the second course code right now on the screen for everybody. So I'm going to read that off. 384291. Again, the second course code is going to be 384291. And I'll leave that up on the screen for everybody for an additional minute.
I want to thank everybody who attended today. There was a lot of material. The course material itself was probably about 17 pages, and I overextended myself again. I had to go quickly, but I hope that you drew something out of it, or something that you thought about that was good about the presentation. We do really appreciate you. I'm in the New York City office of Tully Rinckey, and we have offices around the country, and it's really a pleasure to do these CLEs. So thank you for attending, and I really hope you have a nice day.